So yeah, I'm going to take you through structure real quick. We're going to talk theory because it's important to understand even for the jurisdiction articles, etc. I'm going to also go through some of the examples such as English case law. There's also French ones and also like the actual articles from the your master's collection. And I'm going to do some practice questions. We're going to do, not I. However, these practice questions are of course not the full exam questions because it is impossible to fit it in an hour and 30 minutes. But yeah, these are like the questions that I'm gonna discuss with you are definitely relevant for the exam. So it's gonna be, for example, a sub question or something like that. I will also try to find past exams for you because as I was told, you don't have them and you don't have access to them. I don't have it either, but I'll try searching online. And if I come up with anything during the break, I'll let you know. So yeah, we can start. That's it. That's it for the introduction. So here we have a picture of the contract. I'm sure all of you know what a contract is and you do not really need any legal knowledge for that. But can I ask for the definition? Can any of you tell me a definition of contract? Yeah, you can use chat as well. You can speak up. It's fine. Okay. Okay, so I'm gonna help you. I'm sure you know, but you just don't want to speak up, so I'm gonna speak up for you. A contract is a legally binding agreement between two or more parties. Yeah. Sorry, you wanted to say something? Yeah. Okay. So it's a legally binding agreement between two or more parties where there are obligations which are enforced by law. So obligations that you have to fulfill. So then we have the exam analysis. Here I'm going to take you through based on the past exams that I've been given by my supervisor. So that's what it is. So basically, contract law makes up at least one question of the exam every time. But I've heard they changed the structure this year, but I'm thinking that this distribution will stay the same. So even though I've heard from like previous groups that property law was the hardest for them, I'm not sure if that's your case, but even if it is, property law is going to be just fine as well. Today, just we're going to focus on the contract law, especially since I think that it is one of the main parts of the contributions of the exam. Other than that, family law is the least, it's 9.5%, and mostly what I've seen, and like in my university, it was mostly always the essay questions, not really the legal opinions, because like there's not really much to do in the terms of like the jurisdiction and articles. And then we have tort and property law with the same percentage approximately. So yeah, this is basically me explaining why contract law is important and why you should listen. So yes, moving on. We have a contract. We already know the definition. We talked about it. But now we can distinguish between different types of contracts, and I'm sure you also know that. For example, I am employed by Athena, and thus we have an employer-employee contract. However, you and Athena have a seller and buyer contract because you buy their summaries or trainings or etc. So these are the differences. And this different contracts, this specific type of contracts are governed by their own rules. And these rules can be found in either actual like articles like civil codes, or it can be developed by courts in terms of case law, the binding precedents, etc. Even though cases is mostly common law, we also come across them in civil law, which we're going to see later. Also, another thing that you may want to no, maybe not remember it because not that important, but still there are synalgematic and unilateral contracts. Unilateral means that there is only one party that is obligated to fill out the obligations, and the other party has to simply enjoy the benefit of them. And for the synalgematic, we have that both are bound to each other. So both have to fulfill the obligations, maybe not on the same level, but still both have to do something. So this is like a brief introduction, and then we move on to a more important part, which is the main characteristics, which mostly it's still theory. There's no articles here, still theory, but it is important both for the understanding and if the essay question comes up in the exam, for example, because it's most likely is going to be on one of these questions if there is an essay question on contract law. So I'm going to take you through each and every one of them quickly so you have a better understanding. We have freedom of contract. So freedom of contract like it already tells us that like it gives you the ability to contract with whomever you want, whenever you want, and on whatever terms you want. So you have the individual autonomy to control that. And basically, like theoretically speaking, no one can force you to do so. However, from experience, from like knowledge, from like just like existing, we see that it is pretty much different in practice. So in practice, since we have this such very, very strong power imbalance, it leads to the kind of like a shift of powers, which leads to the lack of bargaining power of the weaker party. Weaker party usually means the one with the less money, and most likely they will not have that much freedom to choose the terms, for example, or even sometimes who to contract with. But theoretically speaking, you can contract with whomever, whenever, on whatever terms. Second, we have the binding force. Well, what binding force tells us is that contract is binding on the parties upon the same level, and no status, money, anything is taken into account in here because it is a democratically enacted statute. This may seem unrealistic because, of course, there are exceptions, which we're going to discuss later. For example, the court is not going to say that you're bound by the contract if the contract really has a very unfair term, saying that, well, if you decide to cancel a membership, you will have to sell your house to us. Of course, like that's a very, very funny example, but still, that of course the court's gonna say, okay, you're not bound by it. So there are some like the levels, the forms which you have to abide to. Third, we have the informality. So this took over, I think, 2000 years to be accepted that contracts can do just fine without the informality, without the formalities, sorry. So there is no need for a template of Google Docs or sheet of Excel to uh, actually have the contract in place. Well, on the contrary, most contracts actually take place verbally, not through written. An example of that would be that if you catch a taxi from Maastricht to Eindhoven, I don't think anyone ever has a form that they make the taxi driver fill out and sign at the end. It's just more like a verbal thing that, well, I catch the taxi accepts my offer, and we go to Eindhoven. So that's the informality principle. And lastly, we have the contractual fairness, which from my point of view is the least precise principle of all. Well, not from my point of view, other scholars also agree, as the least precise principle because, well, can you think of any reasons? I'm gonna give you a hint that it has to do with the word fairness. Do you see any subjectivity, any problem with that word?
Can you repeat the question, sorry?
So there is the contractual fairness, this principle, and it is a bit problematic and vague, especially the word fairness in this. Can you think of any reason why fairness could be problematic or subjective, this word?
Because it's hard to define what is fair and what is not.
Exactly, yeah. It's as easy as that. Everyone has different views of fairness. I may view fairness differently, the countries may view it differently from each other, so it's really, really hard to determine that. But we have a few approaches. No, we have a lot of approaches, but two are the main ones. For example, the first approach says that, well, fairness depends on the outcome of the contract. So if you're treated unfairly, as a consequence to the contract is unfair. And that seems logical, right? But there's also another view saying that if you have the legal capacity to enter the contract and you do it voluntarily, it doesn't matter what the outcome is because you agreed to the terms and whatever is written in the terms is fair despite the practical consequences. We don't care about that. We disregard that. Only the fact that you agreed to it is taken into consideration, but of course voluntarily. So this is basically the kind of like an intro to it and the principles of it. Do you have any questions for me that I might define maybe a little more? Or any ideas?
No.
Oh, okay. I'm still gonna check the chat. No chat. Okay. Then we move on again. So we have now we'll still contract, of course. I'm gonna give you a little tip for the exam. Even though it is open book, still it is like easy to, for example, if you want to define a contract in your essay or in your legal opinion, that's how you want to start. There's always articles in the jurisdiction that define it for you, and you do not have to remember it. For example, there is the Article 1101 of the French Civil Code, which defines a contract, and you can use it and even reference it, and that is completely fine. And it's a little help for you, so you don't have to write out and memorize one more thing. So, yeah, moving on from that. Do you think that if I promise you that the second question of your exam is going to be contract law, definitely, and it turns out to be property law, do you think you can hold me legally accountable? Now, for this, I want you to write yes in the chat if you think that you can hold me legally accountable, and no if you think that, well, nothing's gonna happen, you cannot do anything about it. I'm gonna wait for the answer for like approximately 30 seconds and then we move on. Oop. No. But others also no, 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 no. Yes, all I'm receiving is no's, and that is perfectly acceptable. Of course, you cannot hold me legally accountable. You can hold me morally accountable, but not legally, because court is not really does not really see promises as legally enforceable, because the court says that the main criterion for it to be enforceable, there has to be an intention to be bound, and that is the main thing. So promises are not really the thing you take to court unless they are written out, signed through notarial deeds or through signed deeds if we're in England, and that is the only way you may have the chance to pursue a promise. And yeah, that's what it is. That's the main takeaway here. There is maybe a little historic part, but it's not really relevant for the exam. But for your own sake and for your own knowledge, you may know that historically, it was even harder to prove the enforceability, because for example, in Roman law, your contract had to be in a specific form about a specific situation. I don't know which ones exactly, but like it was very, very harsh. And that was the only case you could get the legal enforceability chance. Other than that, you were all for yourself and you had to figure it out on yourself and like base it on the morality, not legality. Yeah, so that's it here. Any questions for me? Take that as a no. If they come up, just stop me or write in the chat. So we move on to the more important part now. So we know that in order for a contract to be in place, to be effective, there has to be an offer and an acceptance. Firstly, we're going to discuss an offer. So what exactly counts as an offer is the question that we might want to ask ourselves and also analyze throughout the exam, to not mix it up with some other stuff that I'm also going to discuss. So basically, the principles of European contract law, which is soft law, and I think you were advised not to use that in the exam, but like do not reference it. Just like know the content because it explains it very well, and just read it in your own words, and that's it. So, according to this, a proposal is an offer, firstly, if there is an intention to result in a contract after the acceptance, and secondly, if it contains sufficiently definite terms to form a contract. Well, I think first part is pretty obvious, so there has to be intention to have a contract in case of acceptance. But the second is where the questions arise. For example, what do we mean by sufficiently definite terms? We don't really have a list of those terms, right? We do not have any guidelines that says you have to use this word, this word, this word, this word in the proposal to be an offer. No, we don't do that. We mostly derive that from case law, but we also use the reasonable person standard. For example, what would a reasonable person think is this sufficiently definite to form a contract? But it's still a bit subjective, right? Because what do we mean by reasonable person? But still, any person can use this differently. Objectivity is a bit of a hard thing and throughout the law, but in here as well. So that is why we refer to case law. And next, I'm going to discuss this case law, what you're gonna realize what we mean by an offer and what is the distinction between an invitation and an offer, because sometimes they can be mixed together. So we have Gibson versus Manchester City Council. I think you're aware with this case, but it's still gonna go through it because I'm not sure if you covered it. But well, basically, there is this guy, Mr. Gibson, who is a tenant of the house and who really, really wants to buy the house. He does everything. He files the application, he sends the application, he fulfills everything, and the city council gets back to him and says, well, yeah, we might be prepared to sell the house for a specific amount of money. Mr. Gibson says that, well, I think the price is too high because there is a construction work going on in front of my house, so I cannot really access the road. So maybe could you lower it a little, please? Well, the council rejected it and said that no, the price does not change. It stays the same. A few days later, a few weeks later, doesn't matter. You don't need to know the time. In this case, Mr. Gibson writes to the council and says, well, okay, if you don't want to change the price, that's fine. Still carry on with the purchase, please. I'm still buying the house. In this time, after this period, there were some political winds in Manchester City, which you do not need to know of, just know that there were. And thus, for some reason, the city council changed his mind, said that, okay, we're not selling the house anymore, so you may want to find another one. Well, the problem here is that Mr. Gibson saw City Council's response, City Council's invitation proposal as an offer, and he accepted this offer. Thus, he saw all of this as the breach of the contract, which is damages, which requires either compensation or anything like that. So at least the contract has to take place because, from his point of view, it was breached. However, applying both the reasonable person standard and the fact that we learned that there have to be sufficient definite terms, with the court said that, well, it's not really an offer, it was only an invitation to make an offer because the wording of it, as you can see in quotes, it says, quote unquote, may be prepared to sell the house. And I think it's a little bit of a common sense as well, together with the reasonable person standard, that like you cannot sell a house with a maybe or a might or something like that. So anytime you have the case where the offer starts with, well, I maybe will sell the house if I don't want it by next month, or I may sell the house if I find a new one. So this is not an offer. This is just an invitation. This is just like an exchange of thought or whatever you want to call it. In law, we call it invitation to offer. So thus, a takeaway from that is that the offer must have definite terms, and thus any agreement which has vague or incomplete words will never form a binding contract. So it's impossible to do that. Do you have any questions for me? Maybe about the case, maybe about the previous things we discussed. Oh, there is a chat. Let's see. Oh, yeah, you answered yourself. Yes, it's friends. Okay, so you don't have any questions, I'm assuming, right? Then we can move on. So we are now again on offers. However, now we're discussing offers to the public. An example of that could be a newspaper article, journal article, whatever you want to call it, a billboard, anything that is open to the public is seen as a offer to the public. So here is where jurisdictions differ. So French and Dutch law, they say that, well, offer to the public is just the same as if it was made to a particular person. So it's the same level of bindingness. Here we have the case law, for example, in France, we have, which I cannot pronounce, it's a Maritscom versus Braquet of 1969, which says that, well, yes, advertisement to the public is definitely an offer and it is binding. However, there are exceptions. For example, if in the advertisement subject of interest is personal characteristics, then it is definitely not an offer because, like, if there is an article about employment looking for, I don't know, maid or finance, whatever, looking for whatever, it cannot be seen as an offer because personal characteristics have to be taken into account, right? Because you need to know whether the person suffices, whether he's right for the position, whatever. The same applies to property as well. Renting and buying a house, for example, that is also seen as a personal characteristic. So in these cases, it is indeed not seen as an offer. So it's just an invitation here as well. In the Netherlands, it's the same thing, exactly same thing. But if you want to use the case laws, which I think would be good for you since it's open book, you can just write it down and I don't know, shock the examiners, whatever that you know so much. It's the Hofland versus Hennis, which says that, well, an advertisement which is offering to sell a specific property can never be seen as an offer to the public and can an offer to a particular person and as the same bindingness because it's just an invitation to enter into negotiations. So what I think here is that this is a very, very good example of how you can use the overlap of contract law and private law in this case, because I don't know, maybe it can be that the question is not solely focused on one, but it's kind of like a mix of two. But do not worry about it. It's not going to be unclear. It's definitely going to be clear what they're asking of you. So this is a good overlap of that because it includes property law. You may need to analyze the usufruct or whatever from the property law question side, and then from the contract law, you may have this overlap. So that's a good thing. So, are there any questions about French and Dutch? If not, we move on to England and Germany, which I think is more interesting. No questions? Right. So, we move on to English and German law, which is the complete opposite. The complete opposite because they never, almost never, see an advertisement as an offer. They say that, well, it's not an offer, it's just an invitation to treat, invitation to make an offer, and thus you can never hold someone legally accountable to like saying that, well, you printed out an article in newspaper and now you made an offer. Well, you cannot do that. And we have two cases for that. We have Partridge versus Crittenden. What happened here is that basically there is this guy, Mr. Partridge, who has this cocks and hens, brown blonde finch, whatever, and he's selling them. He's saying that I'm selling this for some amount of money. However, these birds are protected by law, and this bird protection organization, you do not need to know, just charged this man, said that, well, you're unlawfully offering cocks and hens which are under the protection. What the court held here was that this was simply an advertisement. An advertisement in English and German law can never be seen as an offer. It's only an invitation to offer. Thus, he could not be convicted, even though there was the price, there was the actual evidence that he was trying to sell them. It was an offer to the public, so you cannot really say that it was either binding or an offer. It was just an invitation to make an offer. And like logically explaining that, the reason for that would be that maybe if someone texts you, oh, I want them, like maybe can you negotiate, whatever, you still have the room for interpretation whether you want to sell it or not. So whether you'll have a contract or not. Secondly, we have the carbolic smoke ball case. So here you have this the actual article that was printed in a newspaper. I'm gonna give you a little bit of background. What happened was that there was this flu from I think 19th century, yeah, which killed over millions of people. And thus there was this company about this carbolic smoke pole case who said that, well, we have this cure, we have this approved cure. If you inhale, I think it was inhaler, if you inhale this, there is no chance you will get the flu, but you have to follow the instructions exactly and you will not get the flu. However, if you still do after taking this inhaler, you can come to us, you can email us, and you're gonna get 100 euros as a compensation. Well, there was this woman, sorry, Mrs. Cully, who did buy the carbolic smoke ball, did use it, she claimed according to the instructions, and still got the flu. Thus, of course, she wanted to get her money, get her back, because 100 euros at the time would have been much more than it is today. However, the company said that, well, are you stupid? Because this is clearly for hype. This is clearly for just like a marketing. Of course, we're not gonna give you your 100 euros. It's simply marketing. It's not even an offer. It's an advertisement. However, the court held here saying that if I'm gonna read out the judgment to you. Well, a part of the judgment, of course, not the whole one. Although offer is made to the world, contract is made with the limited portion of the public that fully fulfills their requirements. Even though a court acknowledges that this was an offer to the public, he says that only specific part of the population who actually buy, who actually use, and who actually get the flu are the ones who are going to be qualified for this compensation. And thus, this is like specific enough, narrow enough to see it as an offer to an individual and have the same bindingness as that and not as an offer to the public. This may seem a little confusing because, well, the first case concluded otherwise, but it's basically just like remember the court does whatever they want within their jurisdiction, within their abilities, of course, so they can decide on case by case basis. And in this case, it was determined that if even though offer is made to the public, if there is a narrower um, audience that it reaches and it qualifies, then it can be seen to have bindingness and can be seen as an offer and thus as a contract. So this is about the offers of public. Do you have any questions for me? If you if you do not have any questions and if everything is clear, please write yes in the chat or plus or anything if everything is clear that I've explained so far. And I'm gonna take an eye on the chat. Yes, 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 yes. Okay, that's great. Thank you. Thank you guys. Thank you very much. So now then we move on if there are no more questions. We're also again on offers because it's a very, very important and a lengthy one. So now we're on goods on display in shops. So it is the same distinction difference here as well. So French and Dutch law say that yes, it is an offer, and English and German law say that, well, no, it is not an offer. We have case law for that. For example, Pharmaceutical Society versus Boots. The case here is that there was a self-service shop who sold non-prescription drugs. The problem here is that many of these drugs, even though non-prescription, they were listed in the poisons list, meaning they may be poisonous. Thus, what the claimant said was that the fact that there was no supervision in the shop, so there were no personnel, there were no helpers, there was only one person standing at the checkout while you were paying. The claimant said that this is a breach of Pharmacy and Poisons Act. So it's basically said that the fact that there's no supervision is not legal. The question here that was raised by the court was that, well, is the contract of sale concluded when the customer chooses the product and like takes it in hand or something like that? Or when they actually go to the self-service checkout and they pay for it? That was the question, and the outcome of the case would definitely depend on this. The decision here was that contract was concluded on payment, so when you paid, and it was done under the supervision of a registered pharmacist, and thus there was no breach. So here we conclude that the contract takes place when you pay, not when you choose. That is the case where it says that it's not an offer. Like it is the English and German approach. In France, we have a different case. It goes for France and Netherlands as well, so they have the same approach. We have the exploding lemonade of 1964. This is the name of the case. You do not need to know the case facts, even though it's fun. The lemonade exploded in the hands of a like I think a customer. I don't know who that was, but like you don't need to know the case facts. Just know the outcome that the sale in French law and also in Dutch law takes place as soon as the customer places the item in the basket. Because it shows that there is the intention to accept the offer. Because me taking the lemonade from the shelf would mean that, well, I'm willing to buy it, right? It's just a matter of time when I will go to the self-service checkout. That is only if I know the price. That's what the court has clarified. So if I see the price, oh, it's $16.99. Yeah, I want that. I take it. And it's just a matter of minutes before I go to the self-service checkout. So in French and Dutch law, sale contract is concluded the moment you show that you have the intention to buy something or to conclude a contract. Yeah, this is the difference. So yeah, French and Dutch law say that yes, the sale is shown by the intention and putting an item in the basket. And English and German law say that, well, no, it only takes place after you pay for it. And paying is the main thing, not the intention to buy. So, do you have any questions? I'll still check the chat. How are we on time? Good. Okay. Okay, no questions in the chat, so we continue. We now have revocation, meaning that there is always, we already discussed the offer, now revocation. What revocation means, I'm sure you know, is that, well, the offerer is no longer bound by his offer, meaning that he withdrew his offer, saying that, okay, no, I changed my mind. I'm not selling my house anymore. And different countries have different approach to this. For example, Germany is the strictest one, which says that revocation is impossible. You have no chance to do it. If you make an offer, you're bound by it. Only in case the person rejects your offer, then you're free to go. Other than that, you have to go on with the contract. In England, we have the complete opposite approach, says that, well, you can revoke anytime you want as long as it is before the acceptance. As long as it is before the acceptance has reached the offer. Sorry, the offeree. So, yes, it's a more lenient approach. France is kind of like a middle one, and I think the most aggressive in terms that, like, yeah, it is the same approach as England, saying that yes, you can revoke the offer before the acceptance, but this will most likely lead to, this will more likely be seen as abusive and will lead to a compensation requirement because French law says this as the fact that, well, the person, the offeree, has had legitimate expectations saying that, well, I was legitimately expecting that this contract would have been done and I made some plans based on that, blah, blah, blah. And France sees this as abusive and thus may ask for compensation. Yeah, this is Article 1 to 40 of the Civil Code. And yeah, this is France. And lastly, we have the Netherlands. Same here. It can be revoked before the acceptance reaches the offeree, and here's the difference, or at the same time as acceptance. So in Netherlands, we have a bit more lenience because it says that not only before the acceptance, but even if I get the acceptance and I send a revocation at the same time, that is still totally fine. And this is the article that I have here of the Dutch Civil Code. And there's also this presumption that new offer instead of acceptance means automatically that old one is rejected. This is not only Netherlands, this is everywhere, but Netherlands like uses this more because it says that, well, if it means that I automatically decline your offer if I make you a new one. That's what it basically says. Any questions about the revocation? I think it's relatively easy. You just need to follow the articles and use your Maastricht collection.
Sorry, can you please one more time explain what is the doctrine of consideration, please?
Uh, uh, the thing is, here in the revocation, it's like basically it's saying that as long as it is before the offeree has accepted the offer, that is just the wording, doctrine of consideration. That's how you use it. You don't need to know any further details. I don't think there is even any further details. It's just the fact that you can revoke as long as the acceptance hasn't reached. That is called the doctrine of consideration.
Oh, okay.
Yeah,
Thank you.
great. No worries. So now we move on to the acceptance part. Well, we have an offer. Imagine that we did not revoke it, and now we're waiting for the acceptance, right? So we have to distinguish between countries here as well. So there are four possible moments at which acceptance takes place, and different countries choose different ones. I'm going to through each of them quickly, and then I'm going to tell you which country is which. First, we have the externalization theory, saying that, well, the moment the acceptance is written, it is effective. The moment you actually write it on the paper or type it on the laptop, that is when it takes place. We have the expedition theory next, which says that, well, the moment the acceptance is sent or posted is when it takes place. So, moment you go to the post mail and send it. Yeah. Or click send on Gmail, anything like that. We have the receipt theory next, which says that when the message is received by the offerer, that is when it counts as an effective date. Meaning that with the moment it comes into my inbox or the moment it comes into my post mailbox, whatever. This is the moment it takes place. And lastly, we have the actual notice theory, which not a lot of countries adopt, and none of our countries do. Is the actual notice theory. It is basically saying that, well, the moment the person reads this acceptance is when it is effective. So imagine that you're on a holiday for 2 weeks. In these 2 weeks, you received an acceptance in the mailbox, but you weren't there to read it, right? So it is not effective from this theory. The moment it will become effective is that when you come back from the holiday, you open the mailbox, you open it and read it. That's the moment that will happen, but not a lot of countries adopt this. I don't even really know a second country that does this, but I'm sure there will be one. So, and all jurisdictions either choose the expedition theory or the receipt theory, meaning that either when it is sent or when it is received. Germany, France, and Netherlands, they have the receipt theory, meaning that the moment that it reaches the moment it is received by the offeror, that is when the acceptance takes place. However, English law always as different, always has something new to say. They have an exception for acceptance sent by mail, where the contract is binding once the acceptance is dispatched. And this is called the mailbox rule. So when you're sending your acceptance by mail, the the effect takes place the moment you go to the, I don't know, the postal point or sending point, and you hand over your acceptance. That is the moment it takes effect. That is called the mailbox rule in England. Other than that, here are the articles that you can find in your jurisdiction in your master's collection. I'm also going to send you the presentation, so no need to take screenshots or anything. You'll have the presentation after and you can note it down. Do you have any questions? I think after this we have a practice question. So if you have any questions, I'm also going to check the chat now, or speak up if you want to. Okay. Okay, if not, then we move on to the practice question. Okay, what I'm going to ask you to do here is I'm gonna read out the question as well, so I'm gonna tell you what it's about. And then I'm gonna give you approximately 2-3 minutes to think of it on your own and write answers in the chat. It's not really long answers, short ones will suffice as well. Just write what you think in the chat and then we can discuss it together. And of course, I'm gonna help you. So, on June 1, Chipotle sent an offer to Taco Bell saying that, well, we're gonna supply you with fresh avocados. And the offer will remain there until June 10. And on June 5, Chipotle said that Chipotle came across some very, very unexpected issues and wants to withdraw their offer. So they do. They notify Taco Bell that offer is no longer valid and they want to revoke it. On June 8, 3 days later, Taco Bell says that, well, I accept the original offer. And yeah, I want to go on with our avocado thing. And they send their acceptance email. However, after that, they found out that Chipotle has already revoked the offer, so there is no longer an offer. The question that we have here is whether Chipotle's withdrawal of the offer was valid and whether there was a contract between them. And I want you to think of it from two jurisdictions perspective. First, do the German law and then do the English law. So do under German law, assess whether Chipotle has the right of withdrawal and whether there was a contract in this case, sorry. And then under English law, do the same. Can Chipotle withdraw the offer under English law? And in this case, was there an offer in the first place? So I'm gonna leave it to you for approximately 2 minutes. Then I'm gonna also go back to the slide that is about the revocation to help you. And I'm gonna wait for your answers in the chat. I think we have to start discussing now. I'm gonna check the chat and I'll wait for your answers. So, okay, I'm gonna ask, like, and you can write yes, no, then we can discuss. Do you think the withdrawal of the offer, wait, I'm gonna go back to the case facts. Do you think the withdrawal of Chipotle was valid under, let's do German law first. Right? Yes or no? Yes. So yes, it was valid, is what thinks. Yes. What about others? Wait, did I ask German law or English law? I forgot. German. Yes. No. Sophia says no. Okay, so the answer is indeed no. Because well, I'm gonna go back here and show you the revocation here. So in Germany, Article 145 says that revocation is impossible, right? Germany says that there is no way, even if it is before the acceptance, there is no way that you can revoke your offer. Thus, in Germany, Chipotle simply would not be able to revoke the offer. That's what German law says. And according to that, then, if he cannot invoke, he not he, if Germany cannot, in Germany, Chipotle cannot revoke the offer, what it means is that, well, the contract is still in place, right? Because if I cannot withdraw my offer, the fact is that Taco Bell accepted. There is an offer, there is an acceptance, and thus we have a contract, a valid contract. Do you understand that? Can you write yes if you understand that and agree? Yes, yes, yes. Okay, perfect, great. And now we have the English law. I'm going to ask you the exact same question. Do you think the revocation was valid in English law? And then answer if the contract was valid, if the contract was there in the first place. Yes, the revocation was valid as there is no acceptance. Do you others agree? Do you also think the same? Yes, yes. Okay, perfect. I'm still gonna explain it a little. In England, revocation is always allowed as long as it is before the acceptance. Well, going to our case facts, we indeed do not have the acceptance before the revocation, and thus we say that Chipotle can indeed withdraw the offer. And the second question, whether a contract exists, well, the answer is obvious, right? If they have the right to withdraw, which they did, then there is no offer. Without an offer, there is no contract. So there is definitely not a contract between these two, and thus there is no breach. So in Germany, there indeed is a breach because you cannot revoke in Germany. In England, you can, and there is no breach of law here. Yes, so this is the answer to practice question one. Do you have any questions before we get a small break? So I'm gonna stop sharing now. If you have any questions, you can type in the chat, you can speak out, you can also stay during the break. And we can discuss them. If not, I'm gonna be here and we'll be back in how long? Do you think 5 minutes is enough? I think this is an
Yeah,
hour.
yeah, yeah.
Yeah. Okay, so we're back in 5 minutes then. Wait, Sophia, I'm gonna read your question now and answer you. So, in England, the acceptance only works immediately when it was sent in mailbox. In this case, if they would send the acceptance by mail email, there would be a contract or no. So in England, oh wait, I'm going to turn on my camera, I forgot. So in England, definitely due to the mailbox rule, if you're sending your acceptance through mail, then it takes effect the moment you send it. So if it indeed it was the mailbox case and they sent it through mail, the acceptance would have been effective, and thus, you're right, there would be a contract between them. Yeah, no worries. Glad to help. So, are we back? Please write something in the chat, a plus, a yes, so I can know when I can continue. Yes, great, thank you. I'll wait for others. Yes. Thank you, Sophia. Yes. So do we need one more, right? Yes, we need Philippine. Maybe we wait a minute, and if not, then Philippine can join us later. Yes, okay, perfect. So we continue then. Share. Mhm. So we covered the practice question very, very well. And now we move on to the next part, which is about the interpretation. Well, what we can say about this is that often there is the case that, well, people sign a contract and they think that they're agreeing to each other. However, they mean different things. Well, they say that, well, I didn't mean this. Well, I got this differently, etc. And this is where the interpretation steps in. There is two different types of interpretation. There is subjective interpretation and there is objective interpretation. And what subjective interpretation basically emphasizes on is that what the parties actually intended. So what was your intention behind these words? This is what the subjective interpretation asks. And on the other hand, the objective interpretation asks, well, did you actually say in the contract? So it disregards the intention. It doesn't care whether you actually meant it or not. It just says that, well, in here it is written like that, and reasonable person would say that this means whatever this means. So there's no need for to know your intention. This is a difference between different types of interpretation. An example of that could be, for example, a term allows buyer to give back a machine. And interpretation of the customer could be that, well, can I give it back for any reason or only due to defects? And this is where the interpretation comes in. This is where the interpretation would play the role. Yes, and this is the difference between them. And now we apply it to our countries that we study. So we have civil law and common law. Civil law loves subjective interpretation, not intention, sorry. Civil law is all about intention, really, really emphasizes on it, and in this case also says that, well, we interpret the contracts based on what we think you actually meant, also in the reasonable sense, of course. And these are the articles for each of the jurisdiction that we have the articles for. But also take into account here that even though it is indeed subjective, often this subjective approach is unclear because you cannot really determine what the party reasonably intended. And this is where the objective approach also comes into play in civil law. And it basically has the approach that says, well, subjective didn't work. Now we're asking, how would a reasonable person interpret this? And that is the objective practice. However, common law, England is not fully, no, none of them are fully, but the most objective it can be because it really disregards the intention. It is all about the reasonableness. So, like, what in England the courts will ask is that, well, we have this contract in front of us, we have this information at the time in front of us. If you ask a reasonable person with a reasonable amount of knowledge, no need for law knowledge or anything, how would he interpret this? What would he think this means? That is the question that we ask. And the principles of European contract law is kind of like a bridge between these two approaches. Always, it's always something in between. And it uses both subjective and objective depending on the situation. What you need to remember from here is that civil law is mostly subjective and English law, common law, is mostly objective. Do you have any questions for me about the interpretation? I'll take that as a no then. And we move on to the ad hoc gap filling, which is also another issue that we have here. The thing is, you cannot imagine how often people forget to include some very, very, very needed terms in the contract. And like from my experience as well, the contracts I read, the things they missed, I thought like a first year law student would know them, not like a 50-year-old man who did contract law for whole his life. But it happens. And when this happens, there has to be some kind of a remedy, right? What can the court do? Well, basically, the court says that, well, if we imagine that they actually discussed these terms, what conclusion would they have come to? What would they have decided on? And they call this the hypothetical will. Basically, the court imagining that you two are the two parties are discussing the term that is missing, and they're hypothetically saying what conclusion you would have come to, both of you. And this is known as supplementary interpretation in Germany and constructive interpretation in France. But it's basically all the same, which I discussed right now. It's hypothetical will, and you can call it hypothetical will in any country. That's the same. What you may also need to know, and it's interesting, is that civil law is I think, the biggest fan of good faith. And civil law, like this principle of good faith, is also used to oblige the parties to consider each other's interests. So it basically says that you do not only act like in the sense of your interests, but you should take others into account as well, right? They're so kind. They're telling you to, well, it should not only benefit you, but both of you. And additionally, there is this thing that is the duty to interpret the contract in like a very reasonable way, of course, and to fill it up in a way that will not significantly disadvantage only one party. It should be somewhat equal. It can never be like fully equal in practice, but somewhat equal. It should not be a very strong advantage or disadvantage to one of the parties. This Article 6248 of the Dutch Civil Code is about the good faith, if you want to look into it. And we have now gap filling in English law. Well, English law says that we're not like you, we're not like losers like you, we don't have this ad hoc gap filling. We have this thing called terms implied in fact. This is Liverpool City Council versus Irwin. You can look in the case facts. It is interesting, but not really needed for this course. It basically says that, well, the court assumes that some terms are like so general and so like obvious that you do not need to either talk about it or even write it because you're implying that it's included. That's what the court says. That's what the common law approach is. And we have two tests for that. We have the officious bystander test. Here's also the case study you can look into. But it basically says that, well, there is a bystander who says that, well, what about the term X? What do you think about it? If the parties would answer that, well, yes, of course, the term is implied, it is so obvious, and given you do not have to look any further into it or write it, then the test is complete. And then we have the business efficacy test, which says that um, which asks the question whether, for example, okay, I know we're missing this term, but is the contract really affected by this missing term, or can it just simply go on without this term? So, can the contract continue existing without any significant consequences in the case of the absence of this term, or is it so significant that the contract fails and falls apart? That's the question that the business efficacy test asks. So this is basically common law. Do you have any questions about gap filling in either civil or common law systems? I'm also gonna check the chat because I know some of you do not have microphones. Okay, nothing in the chat. What about any questions that you may want to speak up on? Okay, taking that as a no again. Now we have unfair contract terms. So this slide is pretty easy. But I'm gonna ask you a question first. Do you think that unfair contract automatically means that contract is void? Oh, not unfair contract, sorry, unfair term in the contract. Does it automatically mean that a contract is void and invalid? I'll wait for yes or no answers. No. Sophia says no. Yes. What about others? No, no, yes. Yes, yes, yes. You are all right. Of course, it would be ideal if it was like that, but it's not like that, right? There are two types of unfairnesses. There is procedural unfairness, there is substantive unfairness. Well, procedural unfairness is on the top of my head. I can think of, for example, having a contract which is formed under incapacity, under duress, under threat, that is procedural. However, the substantive would be that, for example, it includes unfair terms, or there is some kind of like a contract clause written in like smaller shift in white color or something like that that is not noticeable. That is also substantive unfairness. And yes, this is, for example, an example of that could be that I buy a car. It says that it's in a perfect condition. I think that it's in perfect condition, and it turns out to be defective. Of course, I'm gonna claim for damages. I'm gonna breach the contract, get my money back, right? So it basically depends on the extent to which the term is unfair, the extent to which it is misleading. I don't know what misleading is. If it's misleading or unfair or yes, yeah, anything like that. It depends on the threshold always, and the threshold differs between the countries. Here you have the articles 242 and 642 of Germany and Netherlands, which is about good faith again. And it says that good faith can limit enforcing the contractual rights if doing so would be grossly unfair. You can look into these rights as well. I think they're written in a pretty simple language, so I'm sure you will get that. But it's not really something that comes up like most of the times on the exam, so do not stress too much about it. Moving on, we're again on effectual contract terms. So general conditions are used everywhere, right? And like no one actually reads that. Like when you go online shopping and you have to agree to the terms or whatever, everyone scrolls. I've never once in my life read it. Maybe someone did, but I'm very, very hesitant to say that everyone does it all the time. It's not like that. And there are some problems here of the general conditions because, well, firstly, there's the incorporation problem, which says that, well, the could the sorry, wait, well, it says basically that could one party like be so sufficiently sure of what is written there because like they did not really write it. They didn't really take any part into writing it. So would it really be fair? Like, did the customer even know these terms? That's the question. Then we have the interpretation problem, which says that, well, I didn't really draft this contract. How would I know what you actually mean by it? That's what it says. Then we have the fairness problem, which says that especially think of the banks, the bank loans, student loans, for example, they're never there to benefit you, right? Okay, in the short term they may will, but in the long term, no one is thinking about us as the weaker party. And that's the fairness problem is that it most likely contains unfair terms which benefit the stronger party, so the party that was actually drafting the contract. And lastly, we have the contract of adhesion and their problems. It is around the B2C contracts. And there's this approach most of the time that big companies, B2C and B2C contracts, they say, well, take it or leave it. We're not going to change anything. They may even acknowledge that some terms are unfair, but they don't care because most of the times it is so crucial for the weaker party to have the benefits of this contract that they're going to have to take it. And the bigger party, the stronger party, is going to get away with the unfair terms because they have the take it or leave it principle. Do you have any questions about the unfair contractual terms? I think we have 5 more slides and we're done. So, we're again on unfair contractual terms, but this time we apply to English law and German law. Well, in English law, we have this thing called the red hand rule, which was established in Sparling versus Bradshaw. And it basically says that the more unreasonable the clause is, the better attention has to be paid to it. So it basically says that if your contract, if the contract that I'm drafting has a very, very unreasonable clause, I have to highlight it, I have to underline it, I have to discuss it with my client saying that this is the clause. And the more unreasonable, the more attention is needed. This is basically what the red hand rule says. In Germany, we don't have this red hand rule, but we have the articles, the actual articles in the civil code. Article 305C, paragraph 1 says that a clause can be excluded if it is unusual and could not have been expected by a party. What is like the threshold here also differs because we don't really know what is not expectable. But if you get the exam question about this, it will most likely be something so oblivious and so crazy that you will know that it's not expectable, so you don't have to worry about that. Also important in case of Germany is the gray and black lists. We have Article 308, sorry, for a gray list and 309, it's typo here, 309 for a black list. So what do they actually mean? Well, gray list is the list of the terms that actually make the contract not binding in case they are disproportionate. So it basically gives a room to argue saying that, well, you can declare the contract void or the term void if it is disproportionate. However, on the other hand, we have blacklist, which is much more significant, and it says that if the term includes these terms, then it is never enforceable under any circumstance. It can never be binding. And there are the list of the situations, not only like the actual terms, it's not the terms, it's the situations when it happens. And you have, yeah, 308, 309 for that. We're also going to have a practice question about this, so you'll be a little more familiar to it by the end of this lesson. Do you have any questions about unfair contractual terms? Also check the chat. No. Oh, wait, so the substantive is when it is unclear to customer. Yeah, it is something like that. It's not clearly that. It can be, wait, I have some examples if you want. I wrote that just in case there was this question. I'm going to read it out to you what the substantive is. So, wait. Where did it go? So, for example, terms that are unclear, terms placed in tiny font, terms drafted to benefit only the stronger party, and for example, also consumer contracts with no bargaining power. Is that clear? Also, of course, it's not exhaustive list. Anything that is not procedural meaning that like on about the way that the contract was formed, anything other than that would be substantive. You can remember it like that as well. Yes, of course, no worries. So we continue then. We do remedies of the parties. So here, well, the question here is, well, what can I do if the other party messes up and does not really fulfill its obligations? Like, what do I do? There are different approaches here as well. As always, English law is different. In civil law, the default remedy is performance. So they're all about encouraging you to do to do it, to perform your obligations. So like their approach is that, well, you promised to do it, so you have to do it. That's their approach. But of course, there are limits because some things are simply impossible or they're unreasonably burdensome. For example, you cannot really ask Coldplay to write a song 24 hours before their world tour because that is first impossible and that unjust and impractical and everything. And of course, there are limits. It is all in the frames of reasonableness, everything that we study. So, for common law, on the other hand, common law loves damages. So, English law, anytime English law has the chance to pursue the path of damages, they will do it every time because they just love it. I don't know why, but they love it. And like what common law, so English law says is that, well, if you did not perform your duties, pay up. You have to pay up because you had to do it, you didn't do it. We do not care about the fault mostly. Just pay up and this will all be done. That's the approach that they have. A case of that would be Nikon versus Siemens. I don't think this case is very interesting. Do not go into the details. It's not worth your time because it's super long and it basically says that we don't care about fault. We just want you to pay up. In civil law, however, there is the requirement of fault or responsibility for liability. And here I have the examples of the French Civil Code. The first one says that unless the non-performance is permanent, damages are due only if the debtor has previously been put on notice to perform his obligation within a reasonable time. So you can sue for damages only if the person has been notified and said, asked to perform and still hasn't done it, then you can go on with it. And the second article is that, well, I'm not gonna read out to you. It's basically saying that you're liable other than the times where you did not have control over what was happening. An example of that is force majeure. And I'm sure you know what a force majeure is, but I'm still going to give some examples. For example, a natural disaster is a force majeure. You cannot control when there is like an earthquake or something, right? At least I can't. I'm not sure if you can. But yes, this is mostly it. So remember, common law damages, loves damages. Civil law is just begging you to perform. And only in the last, like, it is only the last instance when they allow you to pursue for damages to go on with damages. Do you have any questions about the remedies? The child. Okay, no, I'm guessing no. Then we go back in again to our last slide, and then we have the practice question that I promised you. So now we're on termination for non-performance. Termination for non-performance, well, it is basically allowing the party to end the contract and seek restitution if they say that, well, I don't trust you anymore because you're not performing and I don't think you will perform. But the thing is, you cannot really terminate the contract for anything. Like, you cannot say that there was a missing belt on my bike. Now I want to terminate the contract. It's not like that. That's considered a minor breach. This remedy is only for the severe breaches. An example of, for example, would be the you order a BMW, it comes to you, and the engine is missing. Well, if there's no engine, what is the purpose of the car, right? It's not. So when it kind of like stands in the way of the purpose of the thing or purpose of the contract, then it is a serious breach, and then you can definitely terminate the contract. That's what the court says. But sometimes even minor breaches can be seen as important. And here is where the jurisdictions differ for the thresholds. For example, English law has this threshold of essentiality. So it says that, well, in order to terminate the contract, the term that was breached must be essential. We do not really define essential, like in either case law, it's on a court by case basis. But like logically speaking, it says that if it is important for the contract to take effect and it is breached, then you can terminate. German law has a more specific one. It has the requirement of Hauptpflicht. I cannot pronounce it. You can read it. It's but you can also like not remember it. Just say the main obligation because that's what it means. So it is about. It has to be about the main obligation or failure to meet a grace period. So basically, German law says that well, here we have a contract, and the contract has 5 clauses. The first one is the most important because it says that the item is brand new and not defective. If the thing that you receive is actually defective and doesn't work, you can say that it breached the main obligation of the contract, of like the condition, for example. And if the main obligation is breached, then you can indeed terminate the contract. But if there was like a little scratch or something, I don't think you can terminate a contract for that. Maybe in some cases you still can, but like general principle is that you cannot. Or there's the second case where you have exceeded the time period of making this contract come live, so making the contract effective actually. And that meet of grace period also may be defined by the contract itself as well. So it may state deadlines itself, but also reasonable person standard also comes into the play here because even if the contract doesn't say when my bike will be delivered, maybe I wouldn't want a Spider-Man bike after 35 years of my life. That's just a reasonable person standard. So yeah, court also takes that into account because yes, because they're trying to be reasonable. I don't know the extent to which they are, but at least they try. So, do you have any questions? This was the last substantive slide, the last content slide. Then we have the practice question. I'm also gonna, of course, leave you the room for questions at the end, but if there are some now, I'll answer them now as well. Sophia says no. Good, then it means I did my job well. Okay, so if there are not, now I will ask you to fill out this evaluation form, which is very important. Well, for me as well, because I really hope I was a 10 out of 10 and I did good job and I helped you. But if I was not, that's completely fine as well. This is completely anonymous. You can write your comments, you can write what I can improve, what Athena can improve in general, because we really want to take your opinions into account because I think that what helps the most. It will take briefly 2 minutes. There's only 5 questions, and it's not that you have to write a legal opinion or something. Really, 2 minutes.